Thank you, Mr. Justice Witt. Caribbean Court of Justice, original jurisdiction. Judgment delivery in TTOJ number 1 of 2021 between Rockhard Distribution Limited, Rockhard Distributors Limited, and the State of Trinidad and Tobago, the Caribbean Community, and the State of Belize and Trinidad Cement Limited. The members of this afternoon's panel are Mr. Justice Witt, presiding judge.
Good afternoon, all.
Mr. Justice Anderson.
Good afternoon, everybody.
Madam Justice Rajnat-Lee.
Good afternoon, everyone.
Mr. Justice Barrow.
Good afternoon, all.
And Mr. Justice Jamadar.
Good afternoon, everyone.
May we have the appearances, please? Thank you.
Your Honours, may it please you, Mr. Ian Benjamin leads Mr. Jagdev Singh, myself, Justin Phelps, and Karina Singh. For the claimants, we are instructed by Ms. Nalini Jagnarai.
Your Honour, should it please you, Mrs. Deborah Peake leads me tomorrow, Tuesday, for the State of Trinidad and Tobago. We are instructed by Mr. Brent James and Ms. Radha Sukhdeo, and Mr. Dustin Surrett, a representative of the Ministry of Trade, is present at the hearing.
If it pleases you,
please, your Honours, I'm Dr. Corlita Batschiffer. I'm Dr. Batschiffer, and I appear on behalf of the Caribbean community, together with Mr. Neil Francis.
My apologies, Samantha Matutsaker on behalf of the State of Belize.
Should it please you, Your Honours, Mr. John Jeremy, Senior Counsel, leads me, Raphael Ajodi, on behalf of the second intervener, Trinidad Cement Limited.
Thank you all very much. I will read a summary of the judgment of the court. It is clear that the summary is not intended to be a substitute for the reasons of the court or to be used in any later considerations of the court's reasons. After it had been permitted by the Council for Trade and Economic Development, COTED, an organ of the Caribbean Community, to raise its tariff for other hydraulic cement from 5%, which is the Common External Tariff for CET, to 35%, the State of Trinidad and Tobago requested from COTED in November 2020 a further suspension of the CET in order to increase the tariff to 50% for the entire year of 2021. This was approved by COTED in December 2020. Making use of that authorization, Trinidad and Tobago imposed the 50% tariff from the 1st of January 2021, and it also imposed a quota on the import of other hydraulic cement. The claimants, a regional distributor and 2 Trinidadian importers of cement from Turkey, asserted to be seriously prejudiced by this measure, then commenced proceedings before this court. They challenged the process by which Trinidad and Tobago had applied for the suspension and in particularly the legality of the COTED decision, allowing the requested suspension and the increased tariff of 50%. The claimants alleged that the COTED decision was flawed because of several reasons. It was not based on accurate, relevant, sufficient, and timely information provided by Trinidad and Tobago. There had not been proper consultation of the claimants. Proper procedure had not been followed. The decision was disproportionate and jeopardized expansion of trade and economic relations with third states, one of the objectives of the community, and the decision was given for an improper purpose. An important complaint was also that COTED had wrongly allowed Trinidad and Tobago to impose a tariff for other hydraulic cement far beyond their World Trade Organization WTO bound rate of 5%. The defendants, Trinidad and Tobago, and the community did not agree, made ample written and oral submissions. They were assisted in their defense by two interveners, the state of Belize and the local cement producer, Trinidad Cement Limited, TCL. At the trial, several witnesses and two experts in WTO law were heard and cross-examined. In respect to the WTO issue, the defendants and interveners argued that this court had no jurisdiction to entertain or decide the issue of compatibility of the COTED decision with WTO law. The court frontally addressed this point. It rules that it has jurisdiction to decide whether and to what extent WTO law is part of community law, and whether and to what extent the community, upon a proper interpretation of the revised Treaty of Chavaramas, the RTC, would be bound by WTO law. However, the court has come to the conclusion that in relation to the setting of tariff rates, the community was not so bound. A pronouncement about the WTO bound rate and the legality of a tariff duty in violation of that bound rate would therefore go beyond the limits of this court's jurisdiction. The court reasons and explains that the community must be placed in the WTO universe as a customs union, which provides a perspective from which the nature and possible limitations of the community and COTED must be observed. Given that position, it is expected that COTED, certainly from a pragmatic point of view, will have regard to the WTO bound rate of member states when called to make decisions on the suspension or alteration of the CET, as already was indicated by this court in Trinidad Cement Limited versus Trinidad and Tobago in 2019. However, this does not mean that the community is legally bound by WTO law. The reasons for the conclusion that it is not so bound are that the community, in contradistinction to its member states, is not a member of the WTO. The WTO law is not part of customary international law. That the doctrine of functional succession as developed by the European Court of Justice does not apply to the Caribbean community, and that even though the RTC refers in several provisions to WTO law and its possible application in the legal order of the community, these do not cover or restrict the powers of COTED in Caribbean community law. It is therefore not necessary for the court to delve further into the amply discussed questions of WTO law. With respect to the other challenges brought by the claimants, the court reminds the parties, referring to the foundational 2009 case of Trinidad Cement Limited versus the Caribbean community, that in CET matters, COTED has a broad discretion, and that the court will only interfere with such a decision if it is manifestly wrong. The court found that on none of these bases, the COTED decision could successfully be challenged, let alone justify an annulment of that decision. The court did indicate, however, that the consultation process in Trinidad and Tobago could have been more fulsome and more transparent. On the other hand, the fact that much of the information that the claimants could have provided was not provided was to a certain extent due to their own fault by not taking the opportunity to engage with the competent authority of that state, while they should have done so. With respect to the procedure followed by Trinidad and COTED, the court states first that Part C of the revised procedures and forms, although formally not operative, should nevertheless be followed in its essence or its spirit, if not to the letter. The court reasons that the protocol to amend Article 83 of the RTC, to which these procedures pertain, is provisionally applied since 2015. Further, these procedures were agreed to by the members of COTED themselves. Moreover, the court had already ruled in an earlier decision that good governance, the rule of law, and fundamental values and principles embedded in the RTC require a fair procedure. The court finds, though, that the prescribed procedure was basically followed, although there were some flaws. Given the circumstances, the court finds that these flaws were not sufficient to vitiate the decision of COTED. The court rejects the submission that the objective of expansion of trade with third states had been prejudiced by the COTED decision. The court states that this is just one of the objectives of the community, and that there are others which could conflict with that objective, such as the related, pertinent, inherent objective of the community to create a protected market for producers and manufacturers in CARICOM. The court also points out that the provisions in Article 78 in its several paragraphs, for example, make clear that the expansion of trade with third countries specifically focuses on exports, and that where imports are mentioned, the reference is limited to the importation of goods or products of community origin. It does not cover the importation of products from third states. Of course, this is just a few of the points that we summarized. It's more fulsome in the judgment itself. None of the submissions of the claimants having been successful, the court orders that the originating application is dismissed and invites the parties to make submissions on costs within 14 days. This is the decision of the court. Is there anything, you already got an advanced copy, but let me just ask if there is anything that parties wish to notify the court with.
Speaking on behalf of the claimants, Your Honours, no, there is nothing further that we would like to say.
Ms. Speak.
Your Honours, on behalf of the state of Trinidad and Tobago, in relation to Part B of your order, which relates to submissions on costs, we will respectfully asking whether the court would consider making an order in terms of the one made in TTOJ2021, Motilal Ramit and Sons Contracting Limited, against the state of Trinidad and Tobago and the Caribbean Community and TCL, which is worded as follows. The written submission shall not exceed a total of 5 pages, inclusive of footnotes, with a font of Times New Roman size 12 and line spacing of at least 1.5. That is for the court's consideration.
Yes, thank you. Mr. Benjamin?
Your Honours, I certainly have no difficulty with my learned friends suggesting procedure. It seems to me that 5 pages should be more than sufficient to say what we have to say in relation to cost.
Yes, thank you. Dr. Babsheva?
Your Honours, the Caribbean community agrees, and we do not have anything to add other than to say much obliged to the Honourable Court.
Yes. On behalf of the interveners, Ms. Matut?
If it pleases Your Honor, there is nothing that the state of Belize to add at this point.
Okay. And on behalf of TCL?
No, nothing further, please, my lord. Much obliged.
Okay, well, this is, of course, as you know, a court order, which is already put in writing. But if, as I understand it, the parties that agree that they can keep their submissions limited to 5 pages and with the other limitations, I don't think we have to specifically order that. If you all agree, then you will stick to that. And it is understood that you will approach this particular point in that way. So as there is no disagreement anyway. Okay, thank you very much. Madam Deputy, can you?
Your Honors, just one more tiny matter.
Yes.
Would you all be able to indicate when the final version of the judgment will be sent to the parties or published on the website?
Well, the final version is, as far as I understand, ready. So it should go to you. I can't speak for the registry, but it should be able to. You should be able to get it today, not later than tomorrow.
Yes. And Your Honors, finally, would you permit me, on behalf of all counsel who had the privilege of appearing in front of you, to express our gratitude for the privilege of being able to do so, notwithstanding the painfulness of the result for my clients?
Yes, well, as they say in French, you are nourri dans le sérail, so you know that sometimes it comes with good results and sometimes not so good results, but that is part of this litigation business, so to speak. Okay, thank you very much. Madam Deputy Registrar, can you close off?
Thank you, Mr. Justice Witt. Thank you, Mr. Justice Anderson. Thank you, Madam Justice Rajnatli. Thank you, Mr. Justice Barrow. Thank you, Mr. Justice Jamara. And thank you, Counsel. And thank you to the staff of the Caribbean Court of Justice. This court now stands adjourned. Good day to all. Thank you.